Documents that are provided to the court.
4 things, okay? And I'm asking you, how is that not going to help if I don't give you a continuance? You are essentially asking for a continuance because you're saying they have to keep looking. We have 8 days of trial and they have to keep doing this. What does that mean? How does that compute?
Welcome back to Fair and Square Files, everybody. Thank you so much for joining us. Alec Baldwin, famous actor. Most people are aware that he goes on trial very shortly for the involuntary manslaughter following a fatal shooting on the set of the Western film Rust in October 2021. Gosh, hasn't that time flown by? Baldwin, 66, faces charges he vehemently denies, with the trial poised to determine his criminal liability in the tragic death of cinematographer Halyna Hutchins. Baldwin faces up to 18 months in prison if convicted. Now, most people are familiar with the actual incident, and it occurred when the gun Baldwin was using during a scene rehearsal discharged, fatally striking Hutchins, 42, and injuring director Joel Souza. Baldwin, a renowned actor for many years, contends that he did not pull the trigger, asserting that the gun discharged when he cocked the revolver's hammer. His defense team argues that ensuring the gun's safety was the responsibility of other crew members. Prosecutors, however, have dismissed Baldwin's claim as absurd, pointing out that he did not initially provide this information during his first interview after the shooting. They argue that Baldwin had a fundamental responsibility to adhere to basic gun safety protocols. Additionally, Hannah Gutierrez-Reed, who faced the same charge in the fatal shooting, now she was the gun armorer, received the maximum sentence. Even if the jury finds Baldwin not guilty, his legal troubles are far from over. He faces several civil lawsuits, including one brought by Hutchins' family. In a negligence legal action, they claim the cinematographer's death and other injuries were a likely result on a movie set that contained guns, live ammunition, and the actor inexplicitly pointed and firing a gun at Hutchins. We will be following along with the live footage as it comes to hand. A jury has also been selected for the trial, with Santa Fe County Special Prosecutors and Baldwin's defense attorneys choosing 5 men and 11 women. 12 will be designated as the primary jury, with 4 serving as alternates by the court only after they have heard the case. In the meantime, the pretrial got off to a bit of a rocky start, as you can see, and I thought you might find it interesting. And if you haven't already, if you could hit that big red subscribe button, that would be amazing. It really helps our channel grow. And of course, we now have the membership page, so if you want to be part of the family, that would be much appreciated. All right, let's check out this next snippet where the judge is already getting frustrated with the attorneys. Very early stages for that.
Looking at the kinds of violations like we've seen in this case, it has materially impacted the defendant's ability to be able to prepare for trial, to be able to interview the witnesses, to be able to seek out its own experts and do whatever it is that we need to do on the case when there have been so many continual discovery violations. So the more narrowly tailored remedy that the court could fashion, even though it would not put us completely in the position that we would be otherwise, the closest that we could probably get is if the court were to look at these topics for which we still have these disclosure issues, for which they've now just disclosed these things from their expert witnesses, again, the week before trial when they've had some of these for over a year, and say, I see that there is prejudice, I see that there were violations, and there's prejudice to the defense. So we will not allow the state to benefit or to put on these topics of evidence because the defense is not in the position that they would have been had these documents, had this discovery been disclosed in the timely manner that they were supposed to be. And frankly, while we still want disclosure now, and we are asking that the court lift the redactions and ask for an in-camera review of the documents that we've provided as the exhibits that we still have that are redacted, that we don't have the ability to see the contents of, we would ask that the court lift those redactions so that we can see what's in there. But there is nothing that can cure the fact that these things have been disclosed so late in the day that there's not much we can do with them. So we are asking that those topics that I've outlined in Exhibits N, O, P, and L, that the state not be permitted to introduce evidence or testimony related to those topics, since we are at a disadvantage because of their withholding of this information. And we would also ask that, similar to the other motion that we had done where the court ordered that the jury would be informed of the violation with respect to the Hague report, for example, we're asking that the court allow us to submit a similar instruction with respect to their violations in this instance, so that the jury can know and actually draw their own inference that this information would have been helpful to the defense had they been able to see it.
So you're asking me for 4 solutions. One is to dismiss the case. The second is to eliminate subject matter. The third one is that, which is ongoing, is for them to keep going, keep looking. And then the last one is
the inference instruction.
Well, what you're asking for is a continuance. So why don't you come out and say it? Because you don't want one. How are they going to keep looking for things without a continuance?
What we're asking, Your Honor, for right now is those specific documents that I provided to the court.
4 things, okay? And I'm asking you, how is that not going to help if I don't give you a continuance? You are essentially asking for a continuance because you're saying they have to keep looking. We have 8 days of trial, and they have to keep doing this. What does that mean? How does that compute?
So, Your Honor, what we're asking for is not actually a continuance, and we're not even asking for those extended things. What we're asking for is we've identified a discrete number of documents right now.
You've got to adjust your request then.
Okay, Your Honor, so let me try to do that then. So what we've handed to the court is a number of documents that still remain redacted. We cannot see the contents, is what we've provided to the court. We're asking that the court lift those redactions, or order that the state lift those redactions, so that we can see what those are, because those are clearly discoverable, and yet we still don't have the contents. That's one request that we're making. The other request is related to exclusion of subject matter, and that's because we don't want a continuance. We don't want a continuance.
What is the subject matter you want?
The subject matter, Your Honor, that we're asking the court to not permit are those subjects that are included in those exhibits that I just detailed for the court. And so that would be, yes. And so, Your Honor, what we would like to do at this point, because we understand, again, this is a difficult position. It's difficult for us. It's not where we want to be. It's difficult for the court, because here we are at the eve of trial. We don't want a continuance. The court has already ordered us to meet and confer. My understanding, actually, from Mr. Spiro is that the state had indicated to him, I guess a moment ago before we argued this, that they have some additional disclosures that they would be making. I don't know if that includes potentially what we're asking for with respect to lifting of those redactions. I'm not sure what that involves. I wasn't part of the conversation. So we may be able to get something out of a meet and confer where some of the remedies that we're seeking may already be addressed. So if the court would allow us to do that meet and confer, then perhaps we can bring this again before the court once we know what situation we are in currently.
Thank you. State.
Thank you, Your Honor. Your Honor, first, as the court knows, I'm somewhat newer to this particular case, but the state has complied. I did receive the request, and Ms. Morrissey didn't have the unredacted IPRA. I requested the unredacted IPRA. We went through all of those documents and made those disclosures. They have the information, and the information that they want is information they're not entitled to. So they received information that was subject to disclosure under 5501A6, 5501G, and these are emails is what we're talking about. They're emails with witnesses. And just to give you an example, Judge, I brought the unredacted, and I'd like to give it to the court for an in-camera inspection, and you will see they're not entitled to it. They're not entitled to that information because it's not statements from witness. For example, the email where Ms. Padgett says, we have to disclose this. Well, it's actually the contents of what the person, it's a paralegal emailing the DA's office. That's not a witness statement, and it's just basically saying, hey, we need to get these things, and they need to be disclosed. So if the court would like to take a look at it, Your Honor, for an in-camera inspection, if I may.
Give them a copy?
Well, no, no, Your Honor, because it's for an in-camera inspection, just for the court. So it's the last page, Your Honor, where it begins after Ms. Paget signs, "Thanks, Jennifer." It's a very second to the last page. You'll see it's an email from a paralegal at a law firm. They're not entitled to that. What the defense is complaining about is they want communications between the attorneys. They want communications between paralegals and the attorneys. They're not entitled to that. They're not entitled to our strategy. They're entitled to witness
How
statements.
would they know that? Why can't you tell them they're not entitled to this?
I
Because
did, Your Honor. I went through and I disclosed numerous disclosures. And I specifically in those emails stated, and they attached them as exhibits, these are being disclosed because they were found to contain information that is subject to disclosure. So if it's still redacted, it's not subject to disclosure. And so the other documents, Your Honor, I'm happy to submit those to the court for an in-camera inspection.
I'm not going to do an in-camera inspection. I'm ready for trial.
Yes, Your
Okay.
Honor. And I understand. And what I'm telling you as an officer of the court, as a representative of the state, I went through these.
Why so late?
Your Honor, I was requested on June 27th to do, because
Well, I'm asking the state in general.
Ms. Morrissey didn't have a copy of the unredacted IPRA, Your Honor. So a lot of these happened
Why
before.
did you give them IPRA?
Well, what happened was the defense requested an IPRA in October of 2023. Mr.
Well, you
Baldwin.
knew what was going to happen with that. Balloon.
Yes, and Mr. Baldwin wasn't charged at the time. So that when they received the production from the state, he was then, at that point, charged. I believe it was in May. They asked Ms. Morrissey, would you please unredact? Well, it was thousands, as you noted. Ms. Morrissey asked, tell me which ones you want unredacted, and I'll take a look at them. She received no
This is
response.
all about the IPRA. Is this correct?
Yes, it
This is all
is.
about the IPRA.
It is.
This isn't about any other discovery that was disclosed except what was disclosed in the IPRA.
Yes, and they're witness statements. That's what it is. So a proper remedy, Your Honor, under Harper is a continuance. It's a continuance. They have the information now. As far as the third Hague report, the court addressed that in the Brady motion. As far as this is concerned, they're statements. And the state has gone through, disclosed to what.
Have you already given them the statements?
That's what was unredacted. That's what we went through and unredacted.
What other redactions does she want?
She wants essentially what I just handed to the court.
In-camera, the ones that you said you can't do.
Exactly.
Well, you'd have to make, if they responded that this is privileged information, I can't do it for you. You're gonna have to make arguments on why the redacted portions of the IPRA request that she has kept redacted are fair game. And this is all about IPRA, is what I'm understanding.
There's statements that were obtained, yes, Your Honor, emails. There are thousands of pages of emails. And so, Your Honor, the proper remedy, they haven't shown how they're prejudiced.
So obviously you can tell the court is not happy with this. We are in recess, go confer, and I'll see what's going to happen. I will give you an hour.
Thank you.
We're in recess.